Mr. Flores?
Yes, hi, how's it going?
We have your case set as in person.
Mine's in person?
That's what it said. It's on the docket. It was set for because my judge wanted Miss Reina in person. You're muted, Judge. Mr. Barrera's coming in on Zoom too, Judge.
You recall that? I don't know why.
Well, I remember last time it was in person, and I showed up in person, but they didn't show. But I thought it was in person so that she could submit documents in person.
The last time I clearly told her I was going to do this in person because she's not represented by counsel.
She is represented by counsel.
Who is representing her?
Ricardo Barrera.
When did he come in? The last time that we had a hearing this is Brittany.
Yeah.
Yes,
she just hired him, Judge.
That's the reason that last week we didn't have the hearing, Your Honor, because she hired Ricardo Barrera at the last minute the night before, and he contacted me asking if I'd agree to Rule 11, and I did.
Okay.
That's correct, Your Honor. Rick Barrera here.
All right. Have you all conferred on all this, what your client wants and what the middle ground is here and all that stuff? And because she made some declarations, so I give her another hearing because first she told me it didn't matter, then it mattered a lot. So I was confused about her position.
Your Honor, I was able to spend a good amount of time counseling my client, and the result doesn't matter. The semantics to her very specifically do, and so, and she has a good reason why. She does not want the court to make a finding that there was any kind of relinquishment or turning over, but instead she made a decision as a conservator to have the children or the child temporarily placed or temporarily taken care of by paternal grandfather. So it's just really a case of whether or not, Your Honor, you provide us leave to submit our own order. That you can look at page 15 of 19 of that order. It's a 2-sentence difference. And if the court is inclined based on the outcome to grant one or the other, then my client is satisfied that would be just.
I'm not sure what you're talking about, but okay, Mr. Flores.
Your Honor, yes, it's like she wants the wording to say that the children were with the grandfather, I believe.
Okay, well, do you have an issue with that?
Honestly, I don't, Your Honor, but I do have an issue with the fact that since this ruling was supposed to happen in December, January, February, and March, my clients had to pay child support. But I'd like to add that into the order that he should be credited back that as well. Well, that's the only difference I'd ask for.
Well, he would have to pay child support anyway, regardless of our proceedings, isn't it? True?
No, you ordered no child support, Your Honor.
All right. All right. So what do you want me to do this morning?
If you can just put that on the record that we can have that put in, the additional, have those 3 months credited back to my clients. I don't have an issue with putting the wording that the grandfather was involved. Mr. Gonzalez, you're there. Raul.
Mr. Barrera.
Your Honor, as far as the date that Mr. Flores is providing in which child support would cease, I'm assuming that would be the date either there was an MSA or there was a formal acceptance of some way, Rule 11 or otherwise. I need to clarify.
No. There was no Rule 11, Mr. Barrera. That was a ruling of the judge that because the children would be separated, one of them, Mercedes would be living with my client and Lexus would be living with the mom. Since there would be one child on each side, there would be no child support as of that ruling, which is back in December. I'm sure the court notes will reflect that. We can't look it up on Odyssey because Odyssey's down right now.
The order is in writing and it's in the file. It is what it is. If that's what it was ordered, that's what it was ordered. Yes.
Yes.
Okay, if that's what's ordered, then that's what we have to do. That's the law.
Yes.
So I'll make sure that the order does in fact reflect that. So if there's any funds on hold, provided that they go to father, that order would then, unjingle them to go back to dad, because I don't believe any funds have been distributed to my client since that December date.
Okay. All right. Well, either they're reimbursed to the dad or he's given credit.
Okay, Your Honor.
Okay.
May I just affirm that with my client briefly? I just want to make sure if they're on the record.
All right.
Okay, Ms. Brittany Reina, please.
Yes.
Raise your right hand.
Okay.
Do you solemnly swear from the testimony given be the truth, the whole truth, and nothing but the truth? Help you God.
Yes, I do.
Thank you.
Ms. Reina, you understand that this morning the court is inclined to provide that the date the court rendered that final judgment was proper, that child support was affected by your child going to the paternal grandfather back in December. The child support was supposed to stop in December. Did you get any funds?
Yes, but Lexus has been living with me since, and Mercedes is with his mom. So
It may be so, but nobody came in to disturb my order. Nobody came to tell me that. That now you,
Your Honor,
Ms. Zena, you have an attorney. Hold on a second. Let me just tell you what if the order that I had in place where no child support was not altered by a subsequent proceeding where he said motion to modify that order and I order child support, then that order is still valid until it's changed by order of the court through other proceedings. Was there other proceedings where I changed that order?
but that order hasn't been signed. It was just an order for what, Your Honor? Like, I'm confused.
Well,
Okay, so sorry.
you have an attorney. I'll let you, my attorney, unconfuse you. Let me send you off to a private breakout room and you guys can talk about it.
Mr. Barrera,
I will look at the file. I don't have the entire file, but if I have to go look the entire file, you're gonna have to give me a second to go get my clerk to look it up, all of this. All right. All right, Ms. Zena and Mr. Barrera, when you're prompted, join the breakout room.
Okay.
Hold on, Mr. Flores.
Here, Your Honor, I'll stay.
okay, the room is open.
All right. 2021 DCL 4966, Salinas, Ms. Jones, Ms. Montanaro.
Yes, Your Honor. Good morning. Star Jones on behalf of Ms. Salinas.
Good morning, Judge Aida Montanaro, present for Mr. Fernando.
What do we got on this one?
Well, Your Honor, we were set for I believe, a final hearing today. And for one, this matter probably, well, I guess we've both decided, Ms. Montanaro and I, and we've talked to our clients that this needs to be mediated. There's some outstanding issues that keep coming up every time we're set for final. And that's why we've agreed to Travis Spence. I believe the date that works both for both parties and myself, Ms. Montanaro, and Mr. Benz would be March 28th, assuming that their daughter's surgery goes well on the 21st and there's no complications. Your Honor, just to put some things on the record, I know my client would like to address you. I've talked to her a bunch last week and last night again. She wants to personally address you about some the outstanding medical bills that she's been paying a lot out of pocket, and she's sending over the request for reimbursement, which according to temporary order should be paid within 30 days.
Well,
And
no, I will follow my order. If the order directs him to pay it, Ms. Montanaro, you do the right thing. Talk to your client. He needs to pay it.
He has been.
Okay, well, then there should be no issue.
This lady has, I think, Judge, some kind of mental health issues, because I don't know
Your
what
Honor,
she keeps telling the
Ms.
court.
Jones, let her finish, please.
Judge, I just sent Miss Jones this morning some screenshots that Miss Salinas put on Facebook saying my client, and I excuse the language, is a piece of shit. He left their children on the street. He took their car without prior notice. Temporary orders ordered her to pay her vehicle. She's working. She did not pay it. She said she was going to refuse. She had no money. She told my client to go pick it up. It's under my client's name. It's affecting his credit. He has a state job. So my client said, okay, you know what? Can I go pick it up? Keep making the payments. I don't know what to do. Miss Jones said, yes. My client said, come pick it up whenever you want. It's just sitting there. My client went to pick it up the very next day. Miss Salinas posted up this post on Facebook, calling my client all these names, saying that he had left her out on the street and got a new car. That's one example of the many things we've been dealing with, Miss Salinas.
All right. Well,
that's why we need mediation. There's no talking sense to them. He's paying his medical. There's actually 3 checks, $500 check, a $50 check, and an $85 check that I just sent Miss Jones proof of that he gave to Miss Salinas that she has not cashed for 2.5 weeks because she doesn't feel like it. I don't know what else to do with her, Judge. We've tried to go to mediation and she refuses.
Right. What do you think will be productive? The mediation?
Yes. I need somebody else to tell her how it is.
Or do you want me to take care of it?
I'm sorry.
I will take care of it live if this doesn't settle. I will call you both live the next hearing. Ms. Solis, Ms. Solis,
Yes, Judge.
how long do y'all need to do this mediation?
Well, Your Honor, we have it, I believe we're scheduling for March 28th. I am going to address the medical bills. If I have to do a motion for enforcement prior to then, that may either push back the mediation date, or if we get a hearing to have that heard prior to mediation. Because she has been producing everything, and I am not saying that what Ms. Montanaro said was correct or not. I'm not agreeing to anything that she stated, but I do want all the bills addressed because their daughter suffered an
I'm not,
accident.
what you guys say is not evidence. I'm
Yes,
gonna
sir.
need evidence of all of this. So let's seize the discussion. It looks to me like, you will never agree on what's going on here. And now the court is gonna have to decipher this, and the court will gladly do that. That's my job. So so I'll leave it for the 28th and see where this rolls. If you
Well,
guys,
the 28th is the mediation, Your Honor.
okay, well then I'll move it from then to what, another 2 weeks?
Yes, Your Honor.
All right.
And as I mentioned, if I need to file an enforcement motion, I'll set the order, hoping to
We
get
got
it
plenty of
before.
time to do that. April, what, Miss Elise?
The 14th?
April 14th.
Perfect.
All right.
At 8 a.m., Your Honor, correct? And will that be
In
live
person,
in person?
Yes, ma'am, at 8 o'clock in this court, yes.
Is it live or on Zoom, Judge?
On live, yeah, live, because I've got a feeling that this is going to be back and forth.
Yes,
Yes.
Judge.
That will be live and in person at 8 o'clock.
Yes, Your Honor. Thank you
Thank you.
so much.
Thank you.
I have nothing further. May I be excused, Your Honor?
Yes, ma'am.
Thank you,
Thank you.
Judge.
Miss-
2021 BCL 3626 Tepper. Oh, that's a long one. Mr. Tepper, I see. You got your legal knife sharpened, Mr. Tepper?
You're muted, Mr. Tepper. You're muted, Tepper.
Can you hear me now?
Yes, sir.
I've got my legal pen ready. I just can't get my technical thing going yet. Here I am.
It always happens that way. You have one thing ready, another thing falters. Mr. Garza. Mr. Miles Garza.
Your Honor, this is Juan Gonzalez. I'm on the phone for this, so I'm present.
Okay. Well, the last time
Judge,
I remember this case, you guys were going to confer and figure out what the deal was. There was a discussion that Mr. Tepper had not followed the administrative relief protocol, and therefore this lawsuit was premature. But in between that, I believe you guys were going to discuss some type of resolution, if any, in this. Is that my recollection correct?
Your Honor, what we were waiting for was for Mr. Tepper's dune protection construction permit application to be moved forward because it had not been denied. The court set this for 45 days. I think that you foresaw that things move slowly with government activities, but what I can report to you, Judge, is that the General Land Office provided a comment letter with respect to Mr. Tepper's application. Mr. Tepper is working on responding to that. The county has to do a determination letter, and that's been done. So what is missing is for GLO to get with us one more time, and then we believe that a permit is likely to be issued. To get that done takes two steps, Your Honor. One, there is a dune protection advisory committee. The moment that we hear from GLO in writing, we will set a special meeting for that committee to review the application. They make a recommendation to accept or to issue the permit, but it's only an advisory decision. Then it would be put on the Commissioner's Court at the next available meeting, and the Commissioner's Court will either approve the recommendation or act the way they see fit and issue the permit or not. I believe that a permit is likely to be issued, but we're not the technical people that make those recommendations. So in terms of a timeline, I don't know how much longer GLO might take, but the very same week, I'm confident that the county can get the Dune Protection Committee to have a meeting. And then the county is on a 2-week cycle for commissioners court meetings. So there would be another 2 weeks after that. So I'm not sure how long it will take, but what I can report to the court is that there is movement.
Mr. Pepper?
Your Honor, I have to take exception with Mr. Gonzalez's report. What has happened is that on February 4th, the GLO did comment, and the GLO for the first time ever has required that the county issue a compliance letter saying that everything is in compliance with the coastal management program. This is the first time on any project this has been done since 2006. There have been 3 projects. None of them were required. Number 2 is that the GLO, I responded to on February 14th. I gave the GLO their request for my comments and what they wanted done. I requested from the county, their resource coordinator, a status of their response to this first time ever coastal management request or consistency request. The county has never answered me. I've required 6 times. So I'm going into this. I've never seen their comments, because their comments, they would have to be inconsistent with their program. They say the General Land Office requires that the county affirm that my project is in compliance with the coastal management program's goals and policies. The erosion response plan for habitable structures built seaward of the building setback line are not. And I also want to remind the court that my original petition and my motion for summary judgment basically said that the permit, whether I get the permit or not, doesn't make a difference, because a permit in hand to build structures that are in harm's way doesn't make sense, and we'll be back in here on this. A permit just doesn't make having a permit does not mean that this case is not right. The case is right because what they've done, instead of renourishing the beach program, which protects habitable structures right adjacent to the public beach, they went with the managed shoreline retreat program, which puts in a dune conservation zone and a 230-foot building setback line, which is fine for the county. But at that same time, it says any structures built seaward of that are in harm's way, and their own engineers are saying it. It's in their program. So I just feel that what we're doing here is we'll wait, and this has been going on. I don't see the reason to be waiting, because the county came up with 2 challenges on this, because we're not going over my motion for a taking. What we're doing right now is they want a motion to dismiss. They have not provided any refuting of the fact that my structures will be in harm's way and they're economically unusable, and that a permit will solve the problem, because it won't. And we've got precedent both in Garcia versus Willis County for our state Supreme Court, and on the US Supreme Court, Palazzolo versus Rhode Island, which both say that if you do not have to exhaust your remedies administratively, if it is apparent that doing that doesn't get you anywhere. And at first I volunteered. I said, okay, I'll bring during the hearing, the first hearing we had, Your Honor, you asked us to get together and have a meeting. And at that meeting, which we did have on December 15th of 2021, Mr. Gonzalez finally said, oh, so what you're saying, Mr. Tepper, is that regardless of the permit, you are still claiming a takings? And I go, yes, I am, because you put my structures in harm's way. We had that meeting. At that meeting, at the hearing, I volunteered. I said, well, Your Honor, I might as well go ahead and pull my application off of hold and submit it, which I did on December 8th. So I'm saying that we're at a point that all we're doing is delaying. This is a motion to dismiss, and it says that the court doesn't have jurisdiction. County says I'm not right. And I'm saying,
I get it. You're saying I don't have to be right because the upshot of this is that it is of no effect. The taking has occurred due to your restrictions on the dune conservation policies or the erosion policies that you've instituted. You've in effect taken my property because I can't build on it because they're in harm's way, right?
yes, yes,
Is
sir.
that, do I have it?
Yes, sir.
All right. Mr. Gonzalez?
Well, I think that's a horse of a different color. I have not reviewed the two cases that he's referencing, but the exhaustion of administrative remedies is not necessary if what's going to happen is you're going to get denied. I don't know if this is going to get denied or not. I don't think it's going to take that much longer, but the issue of him saying, if you give me a permit, I still will not build, that's a voluntary choice, because whether or not his property would be in harm's way is a contingency that's undetermined and may never occur. And for that reason, this would not be a matter that would be ripe at this time. But I think that procedurally, and I think the court saw this early on, that the issue of, hey, let's see if he gets one issued or not, is probably procedurally a good idea so that the legal issues shake out the way that they should in an orderly way. If what he's saying is, hey, I don't care if you give me a permit because I'm simply not going to build, but I am going to demand public money in the millions of dollars for making a voluntary choice not to build, that's a horse of a different color. And I'd like the opportunity to brief that if in fact he's saying, hey, you know what, just stop on the permit application, because if he wants to withdraw his permit and take that approach and that argument, then we'll look at it from that perspective and brief that legal issue. But I just don't think that the law supports that you make the claim that at some point in the remote future, you might be at additional risk, which may not occur ever, and still be entitled to be getting public money for a taking simply does not make sense to me, Your Honor. All we're asking for at this point is for a resetting to see if the permit will issue, unless Mr. Tepper is going to say, no, I don't even want to proceed with the permit, in which case I would ask for 2 weeks to brief the issue of getting a permit but deciding not to move forward, because that's a horse of a different color.
Your Honor,
Yeah.
Mr. Gonzalez uses the words will not and cannot. I'm going to use the word cannot. Will not, if I could build, if they would have passed their ERP and had in a beach renourishment plan like the towns, I'd be able to build. They didn't. They made a decision, and it was probably a practical decision, that it saves them a lot of money by pushing back beyond where I'm building and making that a building setback line. They have said, their engineers have said, their consultants have said, and it's in the erosion response plan itself, that habitable structures built seaward of their new building setback line will be in harm's way. And then they go over, there are several instances what they say harm's way will be, with flooding and danger to persons and property and this kind of stuff. So what I'm getting, Mr. Gonzalez has responded to my, if I may, Your Honor, a little history here. I filed, and in my filing, I did say that I was putting my application on hold because I could not build. I did not say will not build. I said could not build. Then the county said, well, they filed their motion. In their answer to my original petition, the county put in, and it was missed by the court because it was inside with no orders, that they filed a motion to dismiss. I responded to their motion to dismiss. I went and filed my motion for partial summary judgment. Mr. Gonzalez got that with exhibits, with the verifications and the recommendations of the precedent cases. And he responded to that within the time frame. And then he reminded the court that he had he had put in his motion to dismiss first. The court saw that it had been fallen in the cracks, so we put that first. But the point is, Mr. Gonzalez has been aware of my position since I originally filed. So, and it's not, I will not, it's not a fact, if you're gonna give me a permit, I'm going, okay, well, I got this permit, now I am not gonna build because I don't want to. Give me some money. No, it's because my project is in harm's way because they decided to do one beach protection program rather than the other. And I guess one more thing is that in 2006, they eliminated this building setback line. And at that point in time, I went and bought property, extra property, and made my multifamily application. I mean, it's rezoned, put in, I did a bunch of stuff. And that was so I could build up to the building setback line, which
the essence of your lawsuit is that you followed what was the town's requirement about your setback, and in order to build, you comply with that on your permit, and then you were confronted with the counties moving the line on you, moving it further seaward, and saying, back seaward, and say, well, this is inconsistent with the city of South Padre Island's setback. We're going to require more setback, and if you build past that setback, you're in harm's way pursuant to our beach protection plan.
Well, no, sir, it was not the towns, it was the county. In 2006, it was the county's plan. The county in 1994 put in a 240-foot building setback line with regard to my property.
Okay.
In 2005, I purchased 2 lots and I had beachfront property because the lot in front of me could not be built on. In 2006, the county redid it, put an amendment to its plan, and that amendment stated that we are deleting the 240-foot building setback line, and we are going to promote development adjacent to the beach. It was the county's plan that was approved by the GLO. And that stayed in effect until 2019, wherein they put in their erosion response plan and moved the building setback line to 230 feet back. So it was the county's plan, not the town's plan.
How did they deal with people that had bought property? Is that so? You're saying basically that if you bought the property prior to this setback being instituted, you were not grandfathered into your original setback?
I'm not sure the question around. Let me see if I can. I want to give you an answer. So,
in other words, normally when you are acting or proceeding under a plan or a law or an ordinance that a governmental agency has in place, you buy something because you say, okay, I've looked into this and I can build this. I can build this because as it exists right now, the regulations of the county, the setback is so much and I can build. So you bought that property under that auspices that you could build, right?
Yes, sir. I bought. Okay.
And then when you were trying to do whatever you're going to build, your multi-unit, whatever complex you were going to build, 3 years later after you bought, they changed the game plan and they changed the rules, and they caused you now to effectively say, no, now if you build, you're going to be in harm's way from whatever, flooding and whatever. Is that after you had bought the property, they changed the rules?
Yes, after I brought, okay, just to make the record clear, I have 3 lots going from the beach to the road in sequence. I bought the 2 lots under when there was a building setback line. All right.
All right.
And then in 2006, they changed the rule. And in 2008, the property went up for sale in front of me and I purchased it because therefore I could build, I needed a beachfront all the way with nothing in front of me. And at that point in time, in 2008, yes, I did buy property. I did pay for the extension of utilities. I did put in hay bales and sand. I did all this stuff in anticipation and went multifamily zoning. And I did buy the property after the county changed the rules and said, you are now allowed to build adjacent to the beach and we're promoting it.
Mr. Gonzalez?
There was a change to the dune protection plan that was going, and we have now a current new plan for this application. Mr. Tepper wanted to be grandfathered into the prior plan, which did not require, I think, a 4-dune protection continuous dune. So he was grandfathered into the earlier plan. I think that Mr. Tepper's belief that he's in added danger or in harm's way is because the new plan foresees a continuous dune protection ridge along the beach. But that is an eventuality. It is what the county desires, but that has not occurred yet, and it would require the participation and agreement of private property owners. So currently, there is no dune, 4-dune ridge that would increase any danger to Mr. Tepper's property. And so I think he's saying, hey, you have this plan that's going to require this ridge, and if it's in place now, my property is at increased risk, and therefore I won't build. But anytime anyone builds, Your Honor, in our view, there's always a risk. For example, in California, people like to build on the mountainside. When it rains, the properties get swept away. People like to build in the forest, and then there's a fire, and people's houses are damaged and destroyed. Here, there is no current ridge that would increase any risk to Mr. Tepper's property. And so it may never occur if we don't have the agreement of private property owners in the future. And so what he's saying, if I'm understanding him, is because the plan calls for this dune to be created, this 4-dune to be created, that therefore it makes it impossible for him to build. I don't know that will never be the case. But that's a different claim than getting a permit and having it denied, which is a typical takings scenario. I understand that there's a scenario where if the regulations are so strict that you can't do what you want, you may have a claim. But his claim here is, even if you let me build, apparently, I'm not going to build because of this increased risk, which may or may not occur. And we don't think that provides the court with jurisdiction. I'm going to refer to the Harris County Flood Control District versus Edward Kerr case. And this was from, the opinion was delivered on June 17th of 2016. And I think what that case stands for is, unless the county has intent to damage someone's property, that there can be no takings in a similar situation. The other issue in the case of Kerr was, one of the claims was that there was a takings because they did not implement their plan. That's where we're at now. We don't have a 4-dune. We desire to have one created, but they found that not implementing your plan is not the grounds for a takings either. My point here for today being, Judge, I don't know that there's any downside for us waiting to see whether he gets a permit. That will give clarity to the Court of Appeals if they need it. Or in the alternative, if Mr. Tepper wants to affirmatively say here today that he doesn't want to go forward with his permit, and he simply wants to stand on the legal theory that he's not going to build because our plan prevents him from doing that, then I would merely ask for 2 weeks to brief that issue, Your Honor.
Pepper.
Your Honor, the county in 2013, the general land in 2012, the county put forth a plan like mine, wherein they were doing an erosion protection plan where they had a 4-dune that was about the same size and height as the one that I've got for my original permit application. The GLO turned that down. In 2013, they had commissioned a study, the Cameron County Erosion Analysis Study. That study said 2 things, and this has been exhibited, and I mentioned it in my response back on his motion to dismiss, that The county had two options. The county could protect habitable structures by doing a plan similar to the town. But the town, that would they would have to spend a lot more money to do it. Or they could do a managed shoreline retreat, do a building setback line like they had done prior to 2006. And therefore they could then and build what they call the dune conservation zone, or not build. Mr. Gonzalez is trying to say that I'm living just on the fact that they're supposed to build a foredune. No, this 230 feet between the public beach and habitable structures is called a dune conservation zone for a reason. In that dune conservation zone, you're supposed to let the dunes build up. The landowners can put in hay bales. Landowners can put in sand fences to build up, to try to build a foredune, because the county, and this they do a lot, Your Honor, the county passes the plan, and an integral part of the plan says that we're going to build this 200-foot wide, 16-foot high foredune to protect everybody. Mr. Gonzalez admits it may never happen. It should have happened. So what happens is that this dune conservation zone is, if you the erosion response plan itself says building within the dune conservation zone is contrary to the goals of the erosion response plan. And then their engineers say it's going to mess things up, and it puts the buildings in harm's way. It doesn't allow the dunes to grow, even if we don't put in a foredune ridge. It's basically, if you're not going to nourish the public beach and stabilize it and even grow it like the town is doing, especially on the north side, then your only alternative is to do a building setback line. And either, if the county is fortunate enough to get landowners to help with the dune, they could do it on their own and get it done, Your Honor, because it's could be done. But if the county had their choice and they chose to do the second, managed shoreline retreat, don't build up the beach, don't protect any property that's adjacent to the beach that we promised we would do in 2006. It has nothing to, the foredune ridge is great, and I hope they do it. But if they don't do it, it's still, I don't have building right there. The dunes aren't going to build up. It's not good for the county. It's not good for me. And if somebody wants to buy a condominium that I'm selling, and they take a look at the erosion response plan, and in it, it says that building are not protected seaward of the building setback line, that pretty makes it economically unusable. They're going to be subject to flooding and danger. They state it themselves. And Mr. Gonzalez is saying, and keeps on leaning to the part that I am willfully saying, hey, give me a permit, I'm not going to use it. No, what I'm saying is, give me the permit, I still can't use it because you put my habitable structures in harm's way.
By doing the setback,
By doing the setback.
240 feet.
Yes, sir. And with that setback comes what they call.
What is the city of South Padre Island setback?
Pardon me?
What does the city of South Padre Island enforce as a setback from the beach?
The public beach, 200 feet, which is
200 feet? So they added an extra 40 feet?
No, they're right at the public beach. The city of South Padre Island their line is the public beach.
Is the mean line, or what the mean tide, or what?
Yeah, 200 feet from the mean low tide. What they did is the city had they called it a historic building setback line. They call it the Hale line, which they're back in the 80s. And when the state required them to start protecting the beach in 1997, the city said, okay, we're going to do this by dredging and bringing in sand. We don't have a choice. We're going to have to build the beach up. So, because we got to protect these condos and hotels that have already been built there. The county had another choice. The county said, okay, we don't have anybody out there that's built yet. So we're going to put a 240-foot building setback line back. for the county beaches. So fine, I went and bought my 2 lots. And so I had beachfront property with the buffer. A year later, they say, oh, forget the 240-foot line. We're going to promote building adjacent to the beach like the town. Now, and that they had a recommendation from their commission, it was in their report or in their plan, that they join the county in nourishing the beach, which they never did. So now all of a sudden, they finally made their in 2012, they came up with the plan that they were going to build a small protection dune. When I say small, 75 feet wide, 11 feet high. And they put that plan before the GLO, and the GLS said, no, it's not going to protect anything. You need to either build a deeper building setback line and a bigger 4-dune ridge, or you need to spend more money and nourish the beach like the town. The county decided that it was going to go with the building setback line, which saves the money.
Yeah, they went to regulation instead of actually spending the money and nourishing the beach.
Right.
Got it. All right. Okay, look, I'm wrapping my brain around this, but it's difficult to wrap your brain around stuff when it's given to you in morsels, bits and pieces, you know? What I would like you to do, both parties, is Mr. Tepper, I'd like you to provide me, or if you haven't already, and if you have, please tell me when you did it so I can look it up, because I don't have the entire file with me. I only have a skeleton file. I need to go into the computer, figure out when you did file it so I can get a copy. I'd like to know, I'd like to read those 2 cases you cited. So if you could please favor me with a copy of that. And
yes, sir, you already have it, but I will be, so you.
Where did you provide the copies of those cases? When did you provide them, Mr. Pepper? That way I can look in have my staff look into the computer and see if I can
I
find
didn't
it.
have a full copy. I'm pro se. I'm not sure I was supposed. I cited the cases. I didn't give you a full copy because.
All right. Well, I'll ask you to, if you can just favor me with copies, because I don't have a legal clerk or research or books or anything that I could just
So
pull
you
off
want
the
the
shelf
full
and look up
you'd like the full copy of both cases?
both cases and send them to me.
I will, sir.
And then they'll give and then provide Mr. Gonzalez a copy of what you're favoring me with. That way we can all be on the same page what the law is, or argue what the applicable law is, and let me make a decision what I believe the applicable law is in this set of facts. Secondly, I want to be clear about this. Your position is not that even if I get the permit, I'm not going to build.
I can't build.
You cannot build. Even if I get the permit, I cannot build under the current setback that you've implemented, the 240 feet setback.
The 230, it's 230 foot. The new one is, the old one was 240, the new one's 230.
The 230 foot setback, under that provision, under that regulation, I couldn't build anyway, because the purchaser would not buy knowing that if I build past that, they would be in harm's way, and who wants to buy a condo is going to get flooded in the first storm.
Yes, sir.
Is that basically it?
That's basically it, except
Okay.
I just want the terminology dune conservation zone to be brought up, that's what they're calling it for a reason.
Right, and my understanding is that the state of Texas required them, rejected their plan and said, no, either you build, you provide a renourishment program of the beach, or you alter the setback.
Yeah, or you do that. They call it Manning Shoreline Retreat. Yes, sir.
Or you address it to the managed shoreline setback. And they, instead of nourishing the beach like the town of South Padre Island has done, the county went to regulation and just moved the setback.
Yes, sir.
All right, got it.
Now, do I submit it just like I would anything else to the court through the?
I just need the copies of the case. You've written a brief that is articulate and clear to me. I think I started reading it and then I put it down once we made a decision. But now this thing is popping up again. I'm going to go back and reread all that. If I have any issues regarding that, I'll make sure I'll pose them to you next time we meet.
Okay.
So what I want to do is I'm going to give Mr. Gonzalez the 2 weeks he needs to respond to these matters. And then at that time, we'll have another discussion, either about the case law, or the facts. But by that time, I'll be more deeply engrossed and deeply knowledgeable about the facts and about GLO and about the setback and about the dune protection plan and all that stuff in my mind. And that way we can have a honest to goodness discussion about this so that I can rule accordingly. Okay?
Your Honor.
Yes, Your Honor.
I'm sorry. I just have a pro se question, Your Honor. When you want me to send you a copy of both the two cases, how do I send it? Do I send that through the regular filing? Or?
Yes, you do it through our website. What's it called? Odyssey, right? How do we do it, Norma?
It's you e-file it.
You e-file it.
I e-file, okay. And that would give Mr. Gonzalez Mr. Gonzalez be all copied on that, or would I need to send him separately if I do e-file?
I think the e-file, Mr. Gonzalez, you will get a copy, right?
Yes,
Yes.
yes.
Okay.
Okay.
Give it 2 weeks, Ms. Solis.
April 24th?
April 24th. We'll see you back here April 24th.
Thank you, sir.
At 8 a.m., Your Honor?
Yes, sir.
Do you want us in person or do you want us by
Would you all
Zoom?
like to come and see me live?
I would, Your Honor.
Your Honor, Mr. Gonzalez likes to make me drive 2.5 hours to get there. I would rather not, but it's up to the court.
I don't mind doing it by
Where are you,
Zoom.
Mr. Tepper? I thought you were living on the island.
No, sir, I live in McAllen.
Oh, that's not 2.5 hours, Mr. Tepper. That's an hour.
Well, by the time, okay, I'm sorry, Your Honor. I think about going to the island. Okay, it's an hour. Yes. sir.
Okay, all right. Well, I'll make you drive an hour,
I
Mr. Tepper.
misquoted.
Okay?
So I would prefer Zoom, but
No, let's go ahead and do it live.
okay.
Yes, Your
I'll
Honor.
show-
24th, I'll see you here live.
I'll show up at the court,
All parties.
all parties.
Yes,
Show
sir.
up-
Thank you, Your Honor. Thank you,
All
Mr.
right.
Tepper.
Thank
All right.
you, Mr. Gonzalez.
All right, take care.
Goodbye.
Bye. All right, let's get back to Mr. Barrera and Mr. Flores.
Yes, Your Honor.
All right, Mr.
So,
Barrera.
he's not logged on?
Mr. Barrera.
Let me text him, log back in.
Yeah, where did he go?
I don't know, but him and I have been talking back and forth.
And
It looks like what we're gonna do to resolve this is, you know how the child support was supposed to resume once Mercedes emancipates, I believe in June, right? It was June 1st is when the child support was gonna kick back in. To offset these 3 months, we're gonna agree to have it move back to September 1st. That way he gets those 3 months back. In other words, since the funds have been distributed.
that's fine.
And so we're gonna go ahead and do that. And we're gonna go ahead and allow the wording of that at one point, the grandfather was a part of the, in other words, the daughter was with the grandfather at one point.
Yeah,
That's it.
eliminate the offending language, sure. I don't think you need it. The
Okay.
one that Ms. Reina is objecting to, don't include that language.
Okay, so we'll go ahead and we won't have so we'll just add in the part about the 3-month change for those, the months that he lost, and then I'll go ahead and submit that to you, Your Honor.
All right, Ms. Reina,
Yes, Your Honor.
what happened to your attorney?
He's logging on. I'm sorry. He's
All right,
getting
well,
on.
I understand that we have an agreement. Where is he? Oh, there he is. Okay. Mr. Barrera. Mr. Barrera,
Yes, Your Honor.
I understand from Mr. Flores that you all have discussed this and come up with a solution about moving the child support from June to September, and that way that will take care of the payments that have been done. Is that correct? The payments that were done in January, February, March up to now. Is that correct?
That is correct, Your Honor.
And I've all told Mr. Flores to agree with you to the language, to remove the offending language or the language Ms. Rain is concerned about, to make sure we don't need it. I think that's a surplus language anyway. So you just make sure that you do not reflect, or do not put that language that Ms. Reina is objecting to. Okay?
Yes, Your Honor.
Okay, you all confirm the final order and let me have both of your signatures on it to make sure that there is no discussion that that's not what we agreed to, whatever. You both review it, and when I see both of your signatures on that order, I will put my signature on it. Okay?
And those are attorney signatures, right, Your Honor? Do you need client signatures as well?
No. Well,
Just
yeah,
give me-
I really, in this case, I don't want it to come back and no, that's not what I agreed to. Well, you get everybody to sign off, Mr. Gonzalez, Ms. Reina, and that way everybody will be happy that you were informed. You did it knowingly, and that way the court will know that I can trust what is in my hand before I sign it. Okay?
Yes, Your Honor. Yes, Your Honor. Thank you.
Okay, thank you all so much.
Thank you, Your Honor. Have a good day.
Okay, yes, sir.
I'll be in touch, Mr. Barrera. Thank you.
Thank you.